Yeah. Sometimes I get so mad, there's no controlling me. My thoughts get so bad, I'm like, I might grab a bat, I don't know. My wrath, my blood boils over like, oh God, here goes. I lost all feeling from my head to my toes. You said some shit that I can't let go, so just stay tuned for the rest of the show. So have you ever felt betrayed? Switches how you see things, realize something needs change. Cause I know you got me fucked up, let me show you what's up. Cause enough is enough. I'll take a face full of pavement just to make a statement. I know there's no turning back. Oh God, adrenaline wasted, so mad I can taste it. I know there's no turning back.
Hey y'all, I hope y'all are having a good day. I am so tired, so we're going to get this done. So we have a special guest today, and she is Amzie with True Crime Gone Mad. And she's muted. She has boys, so sometimes she has to like mute and take care of them. But today we're going to talk about Khori Richins.
My bad.
Hey, you there?
Yeah, sorry, it was double muted. Hello.
Double muted. What is that? Hey, Aussie True Crime.
Oh, when my mute, and don't worry about it.
Okay. Hey, Richie. So we're going to talk about Khori Richins. I know the other day you were like, do you know much about Khori Richins? So I figured maybe other people don't know about her. And for some reason, her lawyers keep wanting to get off of her case, her civil lawyers and now her criminal lawyers. So I'm not sure what's going on with that. That just happened. But the husband that she allegedly unalived is Eric Richins. He had a company called C&E Stone Masonry. Khori had a company called Khori Richins Realty. They had money. And she still was too greedy. She wanted more. So she's accused of murdering her husband by giving him 5 times the lethal dose of fentanyl in a Moscow Mule. I don't know what. Hey, guys. Hey, pink folk. I don't know what comes in a Moscow Mule. Do y'all know? I'm sure it's something I'm not going to drink. Not only did she allegedly kill him with this drink,
Ginger
right?
beer.
It's ginger beer?
Mm-hmm.
Ew.
Yeah, it's ginger beer and vodka, I think. Can we say? It is vodka, ginger beer, and lime juice. And you serve it in like this goldish metal cup with a lime. And they're not bad, actually.
You've had one?
But anyways. Yeah. they're not bad, but they're good on like a summer day or, you know what I mean, type thing. But yeah.
Or wouldn't you want to kill somebody?
Continue.
So she.
Well, that's the thing. They don't really like. That must have just been his drink of choice because there's not really much flavor to it.
Yeah, she said that was the drink that he liked to drink. Not only did she kill him with this drink, but she tried to kill him previously on Valentine's Day nonetheless with a spiked sandwich. I don't know what she spiked the sandwich with.
Well, I think it was fentanyl. It just wasn't enough, right?
Yes.
Allegedly.
Oh, I don't know if she used fentanyl in his sandwich.
I don't know.
She would have to, I don't know if that would be possible.
I just know when she asked for the next batch, she asked for like a lot. She's like, I need a lot. That Michael Jackson shit, which that isn't Michael Jackson shit, but still.
Oh, is Lisa here? Let me put it on all chat. Oops, hold on a second. Hey, Lisa. Sorry, I didn't have it on all chat. Okay, so this is what I think the reasoning of why she did it. So she had a boyfriend. and we're going to go over who her boyfriend is because we just found out who her boyfriend is. And she wanted to be with her boyfriend and leave her husband. However, there's a typo on my page. She was afraid she was going to lose her children and she would have financial difficulties if she divorced Eric because she probably wouldn't get anything from his business. And that was the whole reason why she killed him. But her little plan failed, just like Lori Vallow.
Mhm. Yep. And if it wasn't for the sisters, I think she might have gotten away with it. But he luckily was on to her, and I feel like, that's what, because it was like a year later, right?
But
Until she was arrested and everything.
yeah, it was a while. Oh my gosh. Accused Moscow Mule killer Khori Richins allegedly wanted her husband dead so she could move on with a man who later ended up homeless on the streets of a Utah mountain town because she evicted him.
That's fucked up.
The 34-year-old married mom of three fell for handyman Robert Grossman, 41, after he was hired to work on homes she was renovating. If I was divorced right now and asked you to marry me tomorrow, you would? Richins texted her lover in February 2022, just weeks before she allegedly poisoned her husband. And this is all according to court documents. If I was divorced right now and asked you to marry me, you would? Except would you? She sent that to him, knowing she wasn't going to divorce that man. Oh, I didn't realize she dropped. Hold on.
My bad. And we're back.
Hey, welcome back.
Welcome back.
I don't know if you can hear me. I just want to lay on the couch and cuddle you, watch a murder documentary, and snuggle. 2 weeks later, she texted him and said, "Life is going to be different, I promise," adding, "I hate your hard days. I wish I could be there to turn them around for you. Can I try Friday? Give me a few days. Hang in there until then, please." She messy. Oh, you are not even. Girl, your face is breaking out and everything up in jail. What's wrong with you? This is her husband, and this is the handyman.
She really is.
Look how close they are when they look like. That's crazy.
Hold on, let me see the handyman. Sorry, it's like blocking the picture. Go back up real quick. Is the handyman homeless, you said now? It's fucked up, man.
Let me see if I can make it big. Because she evicted him.
That poor man. I'm just like, wow.
Oh, he had several run-ins with the law. That's probably why she evicted him. I wonder if that's still her boyfriend.
Well, he's like, "Hey, babe, how you doing in jail?" Like,
well, they're like monitoring everything that she has now due to the little stunt she pulled with the Walk the Dog letter story that she was writing. Book she was writing to her mother.
Yes. And I think that her lawyer, because this is a new revelation, right? About the affair. Is this, I think it kind of blindsided the lawyers. That might have a lot to do with why they're pulling out now. Or money.
I don't think it's money because she has money, and the judge froze all of her assets. However, she can still pay for her defense out of it. So
They
she
were
does
like
have the
in
money.
debt, but I guess.
Yeah, she was, but the life, hey, hindsight, the
Oh,
life
that's what it's
insurance
coming
that
out
she
of.
thought she was gonna get,
Outstanding federal
she was gonna get.
tax. So yeah, it says prior to March 1st of 2022, Khori Richins' outstanding state and federal tax liability totaled nearly $190,000. She owed a money lender nearly 1.85 million, and she owed her husband more than 500,000.
See, that's what I don't understand. Wait, I forgot what I was gonna
More
say.
money, more problems, man. That's
I don't know if she killed him for the money or if she killed him to be with the boyfriend and the money. Like it
maybe
had to be the
just get
boyfriend and the money.
divorced. Be like, hey, I got a new boyfriend. As I don't understand these women that have their own business, their own home. Like, I understand if you're stuck, but if you're not stuck, then what's the point of killing somebody? I don't understand killing anybody at all, but I'm saying, like, like, let me rephrase that. I'm just saying that she doesn't really have much motive except for she's just money hungry. That's the only thing I can think of.
Because her business was going under, like she was in so much
Or
debt with
losing
her
the kids.
business. Yes,
Or
she
having
didn't
to
want
share custody.
Right. She was afraid of losing the kids. And also she would write checks from his business to her, and she was making his business, go down and start going into debt and stuff.
Mm.
So after she kills him, allegedly, in my opinion, she did. But anyway, after he dies, she wrote a children's book. It's called Are You With Me? And it's to help children with the loss of a parent and grieving.
I'm like,
After
I have a creepy.
she
Sorry.
Good Morning Show, or what is it called? Good Morning America. What's it called?
Probably Good Morning America. In the Utah version. And she had a comb over and
oh my gosh, I didn't see that.
Here. That's the first thing that stood out to me.
Wow. Okay. I didn't see that until just now when you said something.
It just seems weird.
Right,
she just has a weird vibe. This whole thing has a weird vibe. Her outfit, her hair. She looks like she stays inside hiding all the time. Doesn't realize like her hair's all greasy. Like she doesn't realize how like like I look good.
Her husband was dead when she did this interview. She has to look like that, Amy.
A year later, you don't need to look like your hair don't need to be greasy. Like I don't take a shower. It's the first thing you should do when you're grieving somebody is take a shower.
Yes, you want to go cry in the shower so no one hears you. All right, here we go. I think this is the start.
Or a friend talking about loss with kids can be a tricky subject. Joining us now is author of Are You With Me? Khori Richins, to share her 3 C's to helping kids cope with grief. And Khori, I want to start with your story. What happened in your personal life?
So my husband passed away unexpectedly last year. So it's March 4th was a 1-year anniversary for us. And he was 39. It completely took us all by shock. And we have 3 little boys, 10, 9, and 6. And, my kids and I kind of wrote this book on the different emotions and grieving processes that we've experienced last year, and hoping that it can kind of help other kids deal with this and kind of find happiness some way or another.
And to make sense and process, I'm
Yes.
sure. And I'm
Yeah.
sure you felt that going through and trying to explain it and articulate it for you and your boys.
Yes, exactly. And so I've done, I'm new to all of this, so kind of doing all, research and reading books and things to try and understand, not only how to grieve as a widow, as a wife, but also, with my kids, how to help them understand what just happened. And what I have kind of found is, as I mentioned, it's kind of the 3 C's is how I has visualize it, and it's, connection, continuity, and care. And it's, making sure connection is the major one, and making sure that their spirit is always alive in your home, and memories are always brought up, and doing things that your loved ones love to do, whether it's riding bikes or their favorite dinner, and just constantly, talking about them. And
Khori, do you mention at dinner, here's dad, or dad would like this meal, or dad
Yes.
would,
Yeah.
let's bring dad on a bike ride?
Yeah, exactly. And it's, explaining to my kid, just because he's not present here with us physically, that doesn't mean his presence isn't here with us, and he's doing these things with us. And he's, here for birthdays, and he's here for Christmas, and, and it's just comforting to them to know that,
He would be there for birthdays and for Christmases if it wasn't for you. Can you imagine? She wrote this book with her children, supposedly, for her children and other children that's grieving the loss of a parent. And she's the one that did it. She's in jail right now. She's going to go to prison, no doubt. And now what are her 3 children going to do? They don't have a dad, and now they're not going to have a mother. And how are they going to feel knowing that their mom did that to their dad? And then, like, who said creepy? Lisa, was that you? Yes, very creepy. Hey, Jeff.
Very, very creepy indeed.
As her little widow self says.
They're not living this life alone. Like, dad is still here. It's just in a different way, a different version.
Well, I opened up your book, and one of the first pages I saw is a little boy. It looks like he's standing in a hallway at school, and he's saying, "Are you still here?"
Yes. Yeah. And it's, and that was like the first day of school, and, all the nerves that kids face on the first day of school with new, and just hoping, dad, like, walk with me, like, help me get through today, like, give me the strength to do that. And it has found, it's been a lot of peace for my kids to, to really remember that in the back of their head, that they're never alone,
So you actually wrote this book with your children.
I did.
And it's only been a year. How did you process and say you go from processing death to I need to write a book and help others?
I just watched the struggle that my kids were going through. And I actually, I went on Amazon and Barnes and Noble and trying to find something that we could use to cope at nights. Nights are the hardest, it seems like, for everybody when, dealing with anything. But I just wanted some story to read to my kids at night. And I just could not find anything. I couldn't find anything that really, suited them or helped them find comfort and peace. And so, I was like, let's just write one. And so, I took things that my kids have said to me this last year, and we kind of articulated it and put it into a story, and, just have hopes that it will help other kids.
Grief is not linear, and this sounds like it's a touchstone when you need it to come back to for you and your boys. So the first one you had mentioned was connection of the 3 C's, keeping the person's spirit alive. The second, continuity.
Yes. And then it's, just making sure you're trying to stay, as much as you can on routine. And, whether that's, sports or pick up and drop off from school or community activities, just, trying to stay in a routine as much as possible.
And then the last C is care.
Yes.
What does that mean?
So, on top of just
I forgot I muted myself. Care. Khori Richins, do you even know what that word is? No, you don't.
Loving your kids and hugging them and kissing them and, extra cuddles and everything. I think it's important that I've learned to really affirm, their feelings when they're mad or they're sad. It's just that affirmation of, I understand like that you are upset, because of this, like, let's talk about it, and so I think really it's not, it's the emotional and physical touch of it, but really letting your kids understand that why they're feeling the way that they are feeling, and it's okay, and let's deal with it and talk about it.
There's a promotion right now. Get a free copy of the book April 30th and May 1st through Amazon Kindle. You are an amazing woman and mom, and we thank you for being vulnerable.
I wonder what them ladies think of her now.
They're like, oh shit,
You're so
Like,
amazing.
you're amazing. Good job. Oh fuck. I'm saying that's what they're saying. They're like, oh. But how could you know? How would you know? Like, most people don't, write a book, after they murder someone. At least not like
Lisa, exactly.
book. Yeah, like sometimes people on like death row might write a book or something, but this is different. So they had no reason to think anything weird about it. And it was, I think they took it down for sale, but I think it was still a good book for children.
Did you read it?
Yeah, I watched what's her name? Oh god, Plunder. I watched Plunder read it.
Oh, okay. So she has, dude, wait till you find out what she did to Eric's sister. So, she has civil cases, not just the murder charge for Eric, but she has civil cases too, because the sister is suing for her brother's estate. But for the civil case, those attorneys asked to be taken off the case too. However, I do believe the judge ruled that the sister gets everything.
No, that's good.
And the reason why, I have it somewhere down this presentation. There's a name for it. We'll go over it after. I don't know exactly where it is on here. But this is what Khori did to Eric's sister, because they got into it over who has control of the estate. So she punched the sister-in-law in the face and the neck 2 days after Eric dies, because they were fighting over control of the estate, right? And Khori was convicted of a misdemeanor. Khori didn't know Eric's will states his sister to take over the trust if he died. As she found out, she logged into the insurance company site to change the beneficiary back to her. The insurance company called Eric to let him know what she did, and she was completely taken off, and the sister was put on there. She's like, doesn't this kind of sound like Lori Vallow in a way, like killing your husband for the money and then not getting the money and then going to prison for life? 3 weeks. So they got into a fight. They got into a fight 2 days after he dies. 3 weeks after he dies, Khori sues the trust for the money and assets that the trust lays claim to, that she lays claim to. The judge ruled that the sister gets the $2 million trust, not Khori. I was going to call her Richie because of her last name. This is it right here, Amy. Slayer statute. It prevents killers from profiting off their crimes. So I think that's why the judge ruled against her.
Oh, okay. Having the that makes sense.
Slayer statute. That's the name of it. And then we get to the quote unquote book she was writing in jail called Walk the Dog, which was really a letter to her mom. I read some of it to you while I was at your house the other day. I don't know if you
Mm-hmm.
got to read the rest of it, but it's pretty
No,
telling. And she
very
actually
much.
got charged with witness tampering.
Good, as she should have.
Of course, her lawyers tried to get it thrown out, but it didn't work too well for her.
No.
So I have the court hearing for the Walk the Dog. I can play it. It's 45 minutes long. I cannot play it. It's well, you see it on the screen. Khori Richins' Walk the
Mm-hmm.
Dog letter ruled in court.
Yes.
If y'all want to watch it, I'll play it. You do okay. Let's go.
I can't hear it. Can you hear it?
Sorry, StreamYard lost connection with
Oh no, you're good.
sound. Hold on.
Sometimes my headset's a little weird, so I was like, "Is this my fault?" But
So let's stay focused there. I'm just not sure we're at that point, given the amount of publicity that existed beforehand, what the comments probably said before all of this, the availability of other measures. Dismissal is the ultimate sanction. And correct me if I'm wrong, I don't think you cited a case in which the case was dismissed prior to trial for this kind of conduct rather than during trial. Am I right about that?
Or after.
Okay.
Correct. Candidly, I did not find a case that stated that.
I mean, can we just acknowledge
Yeah.
that during trial, the options are so limited. The jury's already in a box. We
Right.
can't re-impanel.
Right.
Jeopardy's attached.
Right. I think that is a different scenario. I think some of the cases though that came back on appeal, right? Like it didn't get dismissed during trial. The conduct occurred, prior to trial, and those cases came back on appeal, for a new trial.
Those were embezzlement kickback side deal, right? Not pre-trial publicity cases.
Correct.
Am I right about that?
Correct.
Okay.
So I do think it's nuanced, it's difficult in these cases. I think we can all acknowledge that. But there is a process in place to ensure we can do the best we can, to take care that we all do the best we can, not to violate any of her rights to a fair trial. And the state, in their assertions and the statements they've made, have not done that. And the prejudice is we can't undo that, okay? This letter is out there forever, right? Whether it's ultimately admissible at trial, doesn't matter. At this
It
point.
matters a little bit, doesn't it? Because if it were to come
I'm gonna
to
argue it
trial.
matters because I'll probably move to most different to suppress it, but.
Well, sure. So,
Right.
And I'm not expressing an opinion one way or the other
Right.
about any kind of motion in that regard. But imagine the letter came in a trial. Any pre-trial prejudice is now mooted. It's in. The actual jurors have seen it and heard it.
The problem is the statements the state has made during the pretrial phase, right? The statements that they have interpreted, this letter's open to multiple interpretations.
Sure.
Right?
So this lawyer's trying to say that she's not going to get a fair trial because the letter's out there for the world to see. Is that what she's trying to say?
I don't know. That's her defense. It sounds like, which is odd.
Yes,
Should she?
y'all.
I mean, she should.
Y'all sub up to Amzi's True Crime Gone Mad, please.
And yes, we can get to that through cross-examination and
If it comes in.
at trial.
Right.
The problem is that there is local, national, global media where the state has interpreted the letter in the way they want and has put out to the world and all of our potential jurors that Khori's lying, that her witnesses are lying, that her theory is false, that that's the problem. The problem is their statements and the way they've interpreted it, and the prejudice to her is, you can't undo that. I mean, sure, we can probably ask people.
You can't undo the fact that she wrote the letter either. Come on, lady.
Questions in voir dire, but I don't think that's sufficient given the egregiousness of the statement. If it had just been, the way in my opinion, the way it should have been done, or the state's, or the defense's assertion is they could have moved the court for a motion for no contact order. They could have filed it under seal. They could have filed the letter under seal. We could have had this argument or in a way that wasn't the state saying that she witnessed tampered. It wasn't the state saying that her witnesses lied. It wasn't the state saying she's guilty of murder. Those are the problems. And those aren't going to go away. Forever there's going to be this issue that the states said that. And they can't do that. And if the courts, and I granted dismissal is the ultimate remedy, right? But there are alternatives. I don't think any voir dire is going to cure this issue, given the egregiousness of the statement.
So I looked at your, or I should be, defense's proposed alternative remedies. I'm not prejudging a motion to change venue, but you haven't provided a basis to change venue yet. The dynamics that we're talking about, as far as I can tell, exist statewide, nationwide. This case was covered by a BBC. I don't know that you will find jurisdiction that is, certainly not the state of Utah, that is going to be materially different than Summit County in terms of its saturation of media coverage in this case.
Yep.
Correct. I think there will be other grounds, and that motion will come. We're fairly early in the process of this, so I do anticipate moving for a change of venue. Based on I agree. Unless we're going to some tribal land in Ghana, we're probably not finding people where it hasn't touched. But I think there are other issues that we will bring to the court's attention. That we believe would support a change of venue. We don't need to get into that today, but I do anticipate that will be coming.
Then we have disqualification in the Summit County Attorney's Office, and I'm not sure why that follows. Here, at this point, aren't they the most sensitized to the issues and the permissible bounds of what they can and can't say, rather than somebody else? Well, they've been involved. They're going to be subject to whatever ruling they make. I don't understand why disqualification of that office based upon public comments, conduct they take in prosecuting case, making motions, rather than extrajudicial things like those things that exist in other cases that were discussed in the briefing of embezzlement, bribes, that kind of conduct. Here, if you're right that they violated some ethical rules, well, now they know, and I would remain confident they wouldn't do it again.
I don't think that cures the problem.
Tell me why though on a going forward basis. What is it about the continued involvement of the Summit County Attorney's Office on a going forward basis that would be prejudicial to this region?
I think if the court takes no action against the Summit County Attorney's Office, they're sanctioning what they said. And I think that adds additional credence to their statements. And I think that's a problem. Further, they've been involved in the investigation. Allow me a little more. Thank you. So, when they began investigating this case, I was having communication with the Summit County Attorney's Office. So they've been involved since the very beginning of this investigation and throughout it. And so they are intimately intertwined in the entire investigation as it went forward. Further, then they've said that this is our theory, there's no other theory, and the defense theory's got to be a lie because it doesn't fit with our narrative of facts, right? The problem is, you know, there's an insinuation that perhaps they drove the investigation, and this is where it ended up. And if it's
Tell me what you mean by that.
well, they made the ultimate conclusion that she's guilty in their briefing. Okay. And they were involved with the sheriff.
Penelope is barking, and it sounded weird with listening to this hearing, and it's called Walk the Dog, and my dog's barking. Okay.
Office throughout the entire investigation, and they're saying that, you know, any alternative theory, say we, you know, go out and investigate and have investigators working and come forth with additional things or alternative theories or whatever, they've already said that can't be true because it's a lie.
Okay.
And because they drove the investigation or they were so involved in the investigation, I don't, you know, maybe they go look for any. I think the implications of
That's a great closing argument regarding Ms. Richins getting railroaded, but I'm not sure that justifies by itself
I think
disqualifying the Summit County Attorney's Office.
I think in order to fix the narrative that the state has put out there needs to be drastic measures. And one of those could be, or should be, you messed up and you're off the case.
I understand that argument.
I mean, I think that is the only, the only way to correct the violations that we've alleged is to say, you know, that they made mistakes, they violated the rules, and therefore they're not on the case. I think that puts us back a little bit to center where now we can go forward and we can present theories and there's a message out there that says, look, they shouldn't have made those statements, they can't make those statements, and by disqualifying them, the office as a whole, I think it sends a message to potential jurors that that's incorrect. And that there's
Isn't that
potential
problematic as well, though? Or we'd be sending a message, I mean, we'd have to exclude all the jurors that had any sense of that, that were going to draw any conclusions upon that. We need potential jurors that were agnostic about that, wouldn't we? Meaning they didn't have an opinion one way or the other regarding the motives or conduct of any of the participants.
Right, but there's still, I don't think without proper remedies from the court, it restores Khori's right to a fair trial.
Okay.
I mean, at the end of the day, we can't, doing nothing, essentially just adds credence to what they said, and she's in a place now where, you know, we can't call these witnesses, I mean, we're gonna call witnesses, but, you know, we're on the presupposed motion or assumption that, you know, the world has taken that they're liars because that's what the state said. And they can't make those, you couldn't make those in a closing argument. They couldn't get up there and say those things for a reason, right? So you should be able to say now,
Well, I mean, let's be more specific about that. If they wanted to get up and say that, for example, if Ms. Richins testified to X, Y, and Z, I think the state would be able to properly say, listen, compare X, Y, and Z to evidence A, B, and C. The inconsistency shows that X, Y, and Z is a false narrative. That is proper closing argument.
Right, but it'd be based on evidence,
Fair enough.
right?
Yeah.
And you could, that is, I mean, that's what we do, we advocate in closing arguments. You can say, you know, we presented this, the jury gets to weigh the credibility of everybody's witnesses, including the defendant, and make their own determination. They've circumvented that entire process by saying it now. They predispositioned everybody to look at these people through a lens that they're lying, to look at Khori through a lens that she's lying, to look at Khori through a lens that she is trying to get people to lie for her, to look at counsel, frankly, through a lens that I'm doing improper, you know, I'm doing nefarious or criminal acts is what they've alleged. So that's the problem. They have essentially hit every single part of the rule that you're not supposed to violate. And the comment to 3.6 lays out things that are materially prejudicial. So I think that answers that question where they're making these statements now. 3.6 in the comments specifically says these things are materially prejudicial. And those are the things that they've done here.
I understand your position. It won't be the last time you get to talk. Plenty here for the state. Was there anything else you wanted to put on the record in the first place?
No.
Okay.
We'll just,
Mr. Pleasant.
Good afternoon, Your Honor.
State's briefing was a little general in terms of we haven't done anything wrong, there's no prejudice, let's just move on. Address Ms. Lazaro's argument that the things that the state said in its briefing related to the walk the dog letter are not the types of things that the state would be allowed to say in closing argument.
Your Honor, they are the things the state would be allowed to say in closing argument. It is fair argument, fair advocacy based on facts in the record today. And that's an important point here is that consistent with First Amendment jurisprudence on public access, consistent with the court's rulings on public access, these are public debates. These are the debates where the state makes its case in a filing. And the defense has an opportunity to rebut that case in the filing. They just rebutted it, not only in the prior filings, but right here, right now. And that is fair litigation. That is how cases are litigated in criminal courts throughout Utah every single day.
Would you acknowledge that during jury selection, we will need to identify jurors that have no knowledge of a whole long list of things, including the briefing and media coverage regarding the walk the dog letter and the manila envelope and any number of other things?
Yes, Your Honor. Undoubtedly, the court and the parties will select a fair and impartial jury. That will take longer than normal. That will take a jury pool larger than normal, an enlarged questionnaire, expansive voir dire. But there are people in Summit County who are not following this case, at least a dozen or so. And there are people, you know, who we can see as very impartial. Summit County Court set a jury going to Pouch Matter that received tremendous publicity. The court was right to note that much of this publicity is both national and international. More so probably than some county. I can think of 2 pending cases before this court, one civil, another criminal, that are receiving as much local ink as this case. And the court will see some accounting juries in those cases as well. As it relates to the walk the dog letter, and kind of this instant discussion we're having, the Algiers case that I don't remember if it was the state or the defense cites in its briefings, in dicta makes, I think, a pertinent note that the publicity at issue in the prosecutorial misconduct and retrial motion was kind of a drop in the bucket to the overall publicity that the case received over the arc of time. That's where we are here as well.
Okay. Anything else from the state on this motion? We have plenty of other ground to cover.
Your Honor, if your questions are answered, I will sit down.
All right, thank you.
Thank you, sir.
Ms. Lozar.
There are a couple of things I'd like to address.
Please.
So interesting. The first point I'd like to bring up, and we addressed it in our briefing, is the state in their response briefing to this doesn't address really prejudice, as the court just noted. They don't address it at all. That they're, I mean, essentially, what they say is it maybe doesn't matter, that this is out there and so be it. The next thing, I think it's important to look at the statements. The state is saying that they could say these things in trial. They could say these things, perhaps some of them, if they're supported by evidence in closing argument. What they can't say, and I think I'll just pull out a few of the ones that I think are particularly problematic, is, you know, they first say that the court needs a no contact order to prevent the defendant from further engaging in witness tampering. Essentially implying that she's witness tampered before.
Right, but I come back to the hypothetical if they had just charged her.
But they haven't, that's the problem.
I know, but isn't that better for her?
Well, yeah, I don't want no more charges,
Right.
but I agree with you.
But isn't it a proper exercise of prosecutorial discretion to say, that is a distraction to prove that lesser charge? We're going to focus on the top level charges that are in the information.
Absolutely, absolutely. And I don't.
So the only reason I raise that is to say, in that alternative universe that I am describing my hypothetical, the information, the preliminary hearing, all that stuff would be transmitting the message, she's a witness tamperer. That is not different than we have here. It might be worse.
It might be, but it might not be, and here's why. The state concedes in their brief that they didn't have evidence that she ever passed the letter or witness tampered, right?
Right.
So we would actually get to stand up here and say or cross-examine people to essentially prove that that wasn't true.
Well, that's probably
So,
not to
and I don't
too
want
far
to,
in the
yeah, I
direction,
mean, I don't
but
think that
why I'm
matters.
disinclined to prevent her from talking to her mother and her brother.
But the issue is that they have just declared that she's guilty of it, right? Instead of.
Is there anybody in the world that thinks the state of Utah doesn't believe she's guilty of the crimes for which she's been charged?
Is there anybody in the state of Utah? Well, I hope so.
Well, I guess, no, not that they believe personally, but that does anybody out there think the state is just doing this as theater? I mean, the state's position from the beginning is she's guilty.
Right.
I don't think they've been unclear about that.
No, but the problem is that they've used, the way they've drawn the inference between witness tampering and the ultimate decision that the jury is gonna make in this case after it hears evidence is that because she witness tampered, is a consciousness of guilt. You know, she induced people to lie because she's guilty, right?
Isn't that similar to some of the arguments that we heard, on which I relied, during the detention hearing regarding the internet searches? Consciousness of guilt, trying to hide conduct. I guess what I'm saying is that why is making arguments regarding a particular piece of evidence, admissible or otherwise, showing consciousness of guilt, why isn't that a proper conduct rather than improper conduct, whether it gets media attention or not?
Because the rules specifically say that they can't comment on her guilt. The rules specifically say you can't comment on the credibility of her witnesses. The rules specifically, I mean, it's clear in the rules. It's very clear in the rules what you can't do, and that's what they've done here.
But you're not suggesting that the rules prohibit, as a matter of law, making an argument regarding consciousness of guilt in a pretrial finding.
I think when you tie it to the ultimate, I think it depends on the context, right? I think you could use this phrase consciousness of guilt in a number of different ways that doesn't say she's guilty of witness tampering. We're telling you she's guilty of witness tampering, and because she's guilty of witness tampering, she's doing it because she's guilty of murder. And that's what you can't say. You can't go that far. Yes, there are probably a number of ways you could argue that in different ways that may not violate the rules. But the way they've done it here violates the rules because they're specifically commenting on her guilt in this case. The other thing I'd like to address is the ABA standards essentially say there's different ways to do it. Like you could have done it under seal. This wouldn't have been an issue. She spent a vast amount of money. Taxpayers have probably spent a vast amount of money and time on this issue where we're not working, we're limiting our ability to work on other things. We're doing this. Ultimately, this rests on, or what's alleged, she violated a jail procedure policy. As well, if they make that determination, okay? The jail has internal remedies to deal with that. And the jail has decided that she recently violated one of those, and they have prohibited her from contacting her mother. So there were other ways to accomplish this goal without creating a media narrative with the state's position on her guilt and the credibility of her witnesses. And I think I just want to turn the court to the Hensley case. We relied on it in our briefing.
Is that the Fifth Circuit case?
It's a Fifth Circuit case.
That was during trial though, right?
It was.
Okay.
And I get that sometimes it's different. It can be different during trial because you didn't handle the jury. Those are the people who are sitting in it, right? I think that is different.
By implication, no other available alternatives to mitigate potential prejudice.
Correct. But it's still, and maybe maybe these don't get litigated, I don't know. I mean, I don't know the answer to that. Maybe, I don't know how many people, how many arguments are had. If this were a case without a lot of press, okay, if this were normal course, like my 60 other whatever cases I have, right, that are going through the courts, you know, sure, we litigate things on the record, but nobody's looking at the record, right? It's not getting broadcast out to potential jurors. And so when you look at those types of cases in a normal course, it may not be problematic. I mean, it may still be a violation, but the prejudice may not be as grave as it is in this case. Because, you know, nobody would see it, right? The jurors, you know, we have panel juries all the time that have never heard of my clients and have no clue about anything that happened, and you know, they go about the normal course of business. And so the only thing that's brought to their attention are the things that are said in trial. And so that's why I think we see most of the case law come from that, because that's how majority of the cases go. This case is different because this case has so much publicity. Greater care should be taken to ensure we're not tainting a jury pool, to ensure we're not saying the things in pretrial matters that we couldn't say at trial, because the effect is the same. We're potentially causing the same harm that would happen in those other cases to a jury when it's broadcast to the world, where we have, you know, I have jurors that have likely heard of it. And I don't think that the extent that the state has gone to in this case can be remedied short of, I mean, obviously we're here asking for a dismissal, but alternatively, without grave sanctions against the state. And we suggest that they be removed and to start over or continue forward, that's what I should say, with a clean slate, in order to, you know, put some order back in and, you know, go back and ensure her fairness, her right to a fair trial. These premises aren't lip service. I mean, this is essentially the most important thing we can be arguing at this point, is whether or not we can ensure that she gets a fair trial. I think that ultimately is the most important thing in a criminal case. It's, you know, the lofty reason a lot of us started doing this in the beginning, because we were going to be a champion for the rules. But and I don't mean to make light of that. I think that's true for most of us who do this. But it is the most important thing. And so it can't be just, well, as the state says, like, too bad it's out there, we're just going to keep going, it's fine. It's not fine. It's not fine because they violated the rules, and the result of that is worldwide prejudice and a world that thinks that her liars and her witnesses and her counsel, you know, are going to misrepresent things to them or lie to them. And that's a hard thing to remedy.
Thank you for your position.
Thank you.
Thank you. The issue before the court is defendant's motion to dismiss due to prosecutorial misconduct. The gravamen of defendant's motion is that due to conduct by the Summit County Attorney's Office, defendant has been denied due process and her right to a fair trial. Specifically, defendant asserts that statements made by the Summit County Attorney's Office in briefing related to the walk the dog letter, briefing related to the Summit County Attorney's Office request for further limitations on Ms. Richins' ability to speak with her family members, have included statements that violate Rules 3.4 and 3.8 of the model and Utah rules of professional conduct. Those statements include things like, quote, defendant is engaging in witness tampering or needs to be prevented from further engaging in witness tampering. The motion for no contact was based on the defendant's witness tampering and breach of jail security procedures. The walk the dog letter illustrates the defendant's consciousness of guilt. With respect to certain explanations made by the defense for certain actions, that no such link exists in the evidence. That defendant concocts a false narrative. That defendant's own handwriting, she attempts to induce her brother to testify falsely. That she is facilitating witness tampering and supporting a false factual narrative. That she is giving her mother instructions to induce her brother to testify falsely. That this may indeed not be the first time the defendant witnessed tampering, and that defendant is making a frantic, dishonest attempt to explain how fentanyl came to be involved in this case. When viewed in isolation, these comments raise concern that they would cause undue prejudice by tainting the view of potential jurors in Summit County, the state of Utah, nationally, internationally, regarding Ms. Richins, her credibility of her counsel, and her ability to defend herself in a fair jury trial. But when read in context, and given how these comments are anchored to evidence in the record and motions made by the parties, these comments are within the bounds of professional conduct under Rules 3.4 and 3.8. These are examples of permissible advocacy on behalf of the state in support of its request for things like further limitations on Ms. Richins' ability to discuss, contact, correspond with certain family members, and also in response to arguments made by defense counsel related to other litigation topics. Moreover, before this issue arose relatively recently, this case had already received an inordinate amount of media attention, an amount so large that it is frankly not in the interest of justice. But the First Amendment works the way it works, and I can't prevent that. What the court can do and require counsel for the defense and the state to engage in is measures to mitigate any potential harm from publicity regarding the advocacy in this case on a going forward basis. And that would include careful, and detailed voir dire jury selection. We will need to identify jurors that do not have any preconceived notions of the subject matter of this case or any of the people involved in it, parties, counsel, witnesses, etc. That may be a lengthy task, but it was made lengthy long before this issue arose, given the pre-existing publicity regarding this case. Moreover, these arguments would have been appropriate and without objection, the court expects, had Ms. Richins actually been charged with witness tampering. In that situation, the court would be making determinations about whether or not there was probable cause for the charge, and there was probable cause to bind her over for trial, and these very same arguments regarding potential consciousness of guilt and materiality of the letter would have been made and would have been wholly appropriate. Here, based upon the briefing currently before it, the court simply isn't persuaded that the conduct of the Summit County Attorney's Office violates Rules 3.4 or 3.8, or has caused Ms. Richins a denial of due process or a denial of a right to a fair trial. The court is confident that it can preside over a sufficient or dire process to ensure that Ms. Richins does in fact receive a fair trial. For these reasons, the defendant's motion to dismiss due to prosecutorial misconduct is denied.
Denied. Hello, everyone. If you hadn't hit that like button, please hit that like button for me. Thank you. So she's going to trial for witness tampering. The judge did not dismiss the charges and said that the prosecution didn't do anything wrong. So witnesses that will be in the trial include relatives of Eric and Khori, the housekeeper who sold Khori the drugs, and friends of Eric who have recounted phone conversations from prosecutors saying he was first poisoned by his wife 9 years ago. 9 years he knew she was trying to poison. This is the hearing for the hearing being delayed. I'm not playing it. It's another 45 minutes. It was about the pretrial hearing is extended because the prosecution isn't ready, and the defense attorneys asked to be released, in which case they were. So this is where it says judge freezes Khori's assets in case it is later determined by the court that the money should belong to Eric's family. She is only able to afford her defense as it would violate her Sixth Amendment. So like I told Amzi, they have frozen her accounts. However, she can still pay for her defense. But wait, there's more. Who is Khori's mother? This was on Nancy Grace. I'm not going to play it as well because we know Nancy Grace is like 45 minutes long. But her mother, okay, let me see. Allegedly, okay, her mother's partner, I believe she had a girlfriend, wound up dead as well. And she wasn't charged with anything, but I read that I'm not exactly sure how she did it or how it was done, but she supposedly, allegedly, was somehow involved and got away with it. So Khori figured that she could do the same thing and get away with it also. Nancy Grace does have a story on it. Let me put the link in chat for y'all if y'all want to watch it, because it's really interesting. I just don't want this live to be 5 hours long, so I don't want to play every single 45-minute video. So here's the Nancy Grace video talking about Khori's mom and what happened with her and the girlfriend. What did I press? Okay. There you go. I think that's pretty crazy about her mom. And then, like, obviously, she felt like she was going to get away with it too. This is the walk the dog letter. It's 6 pages, but I'm going to go ahead and read it to you real quick. This is what they just tried to get dismissed. Page 1, walk the dog, but take vague notes so you remember. Sky is saying even if the gummies have fentanyl in them, the prosecutor will say I tried to put the fentanyl in the gummies so Eric would have them. Stupid, I know, but that's what she's thinking. We will still test them though. However, she wants to link Eric getting drugs and pills from Mexico. So we need some kind of connection. Her private investigator is doing some research on the ranch cartel place Eric would stay at. Here's what I'm thinking, but you have to talk to Ronnie. He would probably have to testify to this, but it's super short, not a lot to it. He will need to tell Sky at the meeting next week. Upon information and belief, just like they say, a year prior to Eric's death, Ronnie was over watching football one Sunday, and Eric and Ronnie were chatting about Eric's Mexico trips. Eric told Ronnie he gets pain pills and fentanyl from Mexico from the workers at the ranch, but not to tell me because I would get mad because I always said he just gets high every night and won't help take care of the kids. There are pictures in my phone of Eric passed out on the floor or in the chair. Ronnie should have texts from Eric talking about getting high as well. Eric told Ronnie he keeps them in an allergy pill bottle in his work truck so I wouldn't find them. Ronnie never told me about the conversation. Eric finally told me and asked if Carmen could get him some. I guess Carmen's the housekeeper. Eric never wanted anyone to know he had an issue, especially get caught. He always wanted Khori to go down for him. When they traveled, Eric would put his drugs in Khori's bags at the airlines right before they boarded. That way, if they were caught, Khori got in trouble, not him. What happened to it? What happened to the page? When you talk to Ronnie about this, meet up with him in person. I worry sometimes your house and phone are bugged. Maybe drive down to. What is wrong with this thing? Are you kidding me right now? I just read the whole letter. Where is it? Download to read. There it is. She puts all his drugs in her luggage at the airport so that she'll get in trouble if they get busted. And she wants the brother to lie. I saw a commercial yesterday. Utah Mortgage Relief. Google them, please. Oh my gosh. Anyway, it's all to the mom for the brother to go to tell the brother what to testify and to go to the other witnesses and tell them what to testify. And that's why she got charged with witness tampering. If you want to read the whole letter, it's right here. That's the link for that. So that's what the hearing was about. This letter, walk the dog letter. They wanted it dismissed, but the judge said no, it will not be dismissed. So not only is she facing murder charges, but she's facing the tampering, witness tampering, and okay, Pink Poberto, I love you. I'm about to end right now. Needs new attorneys. So I don't know what they're going to do about that. I guess we'll see who she gets to be her. She doesn't have a public defender, so she will have to find her own attorney. I wonder if she found another attorney yet. I don't know. If you know, put in the comments and let me know if she already has another attorney, because she's going to have to pay for it. I don't think she can get a public defender. She has too much money for that. All right, everybody. Sorry, Amzie had to leave. Her internet's crazy, but we know I tried to go live from her house and I got cut off twice. So her internet is wonky. But anyway, I will be live tomorrow with the trial, with the treadmill murder trial with the dad. Don't forget, I thought they were going to not go to court until tomorrow. Yeah, Wednesday. I keep losing track of time because I was supposed to be off Monday, but I worked on my days off. But they went to court today, but the jury wasn't there. So I'm going to stream that tomorrow, and then the jury comes back tomorrow, and then we'll go from there. I don't think they have court again on Friday, though. On that note, I hope you all have a wonderful rest of your night. I hope you hit that like button for me, share, and subscribe, and I will see you all tomorrow. Bye.